Hello, and welcome to this Medical Protection podcast. My name is Tim Cookson, and I'm a medico-legal consultant to MPS. Today's podcast is entitled, Is the Truth Important? And it's about fairness, it's about the Office of the Health and Disability Commissioner, who we'll refer to as the HDC, and it's also about capacity assessments. Joining me today are my colleagues at MPS, Dr. Sam King. Hello, Sam.
Hey, Tim.
And Dr. Lucy Gibbard. Hi, Lucy.
Hi, Tim.
Now, look, I make no apology for talking about the HDC again. It's the major player in the complaints area for New Zealand clinicians, and in addition, the complaints process can have a very significant impact on the well-being of our members who find themselves in the spotlight. We're going to look at a complaint and start by assessing, whether it suggests any vulnerability for the doctor involved. And this may give you some idea too of some of the workings within MPS and how we assist our members. Now, I have the consent of the doctor involved to use this case for teaching purposes, but of course I've changed some details so that the patient is not recognisable. Now, it's important to note that this is not a complaint that will appear on the Commissioner's website. For those of you who have looked at the decisions on the Commissioner's website, you'll realise that virtually all of the cases that are published by the HDC involve a breach of the code in some way. And, you have to think, as someone, perhaps a non-medical person reading that all that happens when there's a complaint about doctors is that they've breached the code, they've done something wrong. And that doesn't seem very balanced to me. And you've got to read the fine print, really, of the HDC website, their annual report, to see that out of the 3,500 complaints that they've had, there have only been 90 or 100 perhaps where there's been a breach finding. But that's not obvious from when you read the case reports. And so we just want to look at what happened during this complaint and think about that process.
Do you think we should be trying to encourage the HDC to publish non-breach decisions?
I have actually approached them about that, and they said that there's some reason that I couldn't quite understand as to why they couldn't publish. There's the odd one where there's no breach, but they're all investigations, of course, and I think it's fair enough that it's only investigations that get published. And as we know, if something goes to investigation, it's actually very likely to be a breach finding anyway. So, but it would be quite nice if there were other cases there to help balance it out, so that the public doesn't get that feeling that, we're all just making mistakes all the time. But I don't know how best to do it. But it is a concern that I have.
I think it's nice that we're able to talk about cases that we've had where there has been no breach finding, and I think this is a case in point where we actually get a good outcome for our member, a right outcome for our member. So I think the fact that we're putting out podcasts and talk about our cases actually brings some balance.
Great. Well, let's get into it. So, Sam, would you mind reading out the complaint for us?
Sure. My mother was terminally ill with cancer and had been on morphine for years. Concerned about drastic personality changes and delusional thoughts that we witnessed with Mum towards the end of her life, my brother and I went to Dr. John Smith, Mum's doctor. Dr. Smith explained this could happen with terminal illness and long-term use of morphine. Aware of the situation but not having seen my mother for a number of weeks, Dr. Smith was contacted by a lawyer asking for a certificate of competency so they could change Mum's will. Dr. Smith, without having seen my mother for weeks, issued the lawyers this certificate in writing. No examination or physical sighting and conversation with my mother. No investigation into her current state or effects of her medication was performed. This certificate of competency should never have been issued, and we want the doctor to revoke it. I have met with the doctor who admitted that the drugs Mum was on can affect competency, and also that that terminally ill patient's capacity is greatly affected at this end stage. Still, they said they could not retract the certificate. I believe they know they've made a huge mistake, and my brother and I have lost the family home, and now we have huge legal bills fighting this.
Okay, Lucy. Well, it's it's clearly an issue where there's been a significant impact. And look, we've talked about competency assessments in the past in some detail, but maybe just based on the kind of limited information that you've got from the complaint, do you want to comment on whether it appears that a proper assessment has been made of this lady's competency in the final stages of her life?
Yes, well, we've only got the complainant's idea of this, and I think
Yep.
that's the first kind of issue here, isn't it?
Yep.
But if what the complainant has said is correct, and Dr. Smith hadn't seen the mother for weeks and hadn't done an examination or a physical sighting or had any conversation with the patient and hadn't investigated the effects of medication on her, well, in that situation, it would suggest that she hadn't had a competency assessment, because a competency assessment is normally a reasonably thorough assessment where you talk to the patient, discuss around the issues and see what they're understanding, whether they can weigh up pros and cons, whether they can communicate. All those things require time and a contact with the patient. And if he'd had no contact with the patient, it's hard to see how he could have done that.
Yeah, no, I certainly agree, and it kind of leads on to the issue that we sometimes see, firstly with lawyers wanting an assessment done very quickly, so we need this information within 3 days, or even worse, I think, is the public trust writing to you and saying, can you let us know whether 3 years ago you thought this lady was competent to sign her will? Any comments on those scenarios?
Oh, goodness, we get those all the time, don't we? Where a will has been challenged years after it's been made, and the lawyer writes a letter saying, please, can you tell us what Mrs. X's competency was on the 22nd of May 2009? And of course, the patient hadn't seen the doctor on or around that date, and so there was no way of being able to retrospectively do that. And similarly, that whole issue of, I need to know if this patient's competent, just sign it. We need it in 3 days because there's an emergency with this, that or the other, and the doctor feels like there is pressure on them to provide an assessment of capacity without actually having the time or the information to actually do that assessment properly, because you actually do need background information before you do a capacity assessment.
Yeah, I think that we doctors tend to be fairly trusting. So when we get a lawyer letter, we assume the lawyer knows what's right and what's appropriate to do in the situation. So some doctors do just do what the doctor requests. I mean, what the lawyer requests.
Yeah.
And which is obviously not the right thing. I mean, lawyers will often try and get away with what they try and get away with.
But I think it's also that you're often trying to be helpful,
Yes.
and that the doctor involved is often thinking, oh, well, they need this. The patient needs me to do this in order for their wishes to be fulfilled. So I'm doing this for my patient. And so you feel like you're in a situation where if you don't do it, you're letting your patient down. Whereas in fact, this is one of those situations where you're not an advocate for your patient. This is a certification issue. And actually you're expected to make an independent assessment of your patient's capacity without taking that kind of advocacy role for what you think might be the right thing.
And the Medical Council certainly has got statements on this as well, hasn't it, on certification and the need for it to be accurate and to be properly considered, et cetera, et cetera. So, yeah, from the information we've been given, it does look as though a proper assessment has not been done. So on that basis, you'd say, yes, that's a reasonable grounds for the complaint. So look, let's go back to the HDC. This complaint was received by them on the 15th of October in 2023, and then 4 months later, the HDC wrote to Dr. Smith and to the complainant at the same time. Now, just by way of background, on the HDC website it states, the Health and Disability Commissioner promotes and protects people's rights as set out in the Code of Health and Disability Services Consumers' Rights. This includes resolving complaints in a fair, timely and effective way. And I think it's important to think about those words as we go through this complaint. So this complaint, yes, as I say, took 4 months for the response, well, for a letter to be sent out both to the complainant and to Dr. Smith. The HDC letter to Dr. Smith basically just referred him to the letter that the HDC had sent to the complainant. And the letter to the complainant states, "I'm very sorry to hear of your situation and I can appreciate your frustration. I have carefully considered your complaint about Dr. Smith and have decided to refer it to the Medical Council of New Zealand because your complaint raises concerns about the appropriateness of Dr. Smith's conduct. The Council will consider the complaint and decide what action is required. The Council is also required to report back to the HDC on the outcome of this referral." Sam, you'd have to say that the conduct that's been outlined does raise concerns. So is this in fact a reasonable decision by the HDC to say this is a conduct thing, better for the Medical Council to look at it, and rather than having the HDC look at it first and then for it to go to the Medical Council, is this a sort of a smoother way of processing this particular complaint?
That's a really interesting question, because from time to time the HDC do make these sorts of decisions, whether to investigate it themselves or look into it themselves, or whether to pass it to the Medical Council. And it comes down to an issue of jurisdiction. And I've certainly had cases where I have felt that the Medical Council would be more an appropriate forum for whatever the conduct happened to be. However, the HDC have decided to hold on to it and investigate it, as well as sending it to the Medical Council. So doctors end up going through this dual process, which, it's bad enough going through one process, right? But to have both of these agencies investigating the same conduct is, doubly stressful. So I think it's far better, if possible, to have either or, but not both. And so in this sort of situation where they have made an assessment, they haven't heard from Dr. Smith.
No.
And so I guess the question is, would it have been better, a fairer process, for them to have asked for Dr. Smith's side of the story, his account, before referring it to the Medical Council?
But, is referring it to the Medical Council a big deal? Should Dr. Smith be worried about the fact that it's going to be referred to the Medical Council?
I think all of us are worried when anything goes to our regulator, to be honest. Yeah. Even if it's a fairly brief process through the Medical Council, I think it's still very stressful. And look, I would say that there are situations where the Medical Council deal with things in a far better way than the HDC process. And I think that really does depend on each particular case.
Mm-hmm.
And how would Medical Council look at this particular complaint? I think they would see it as potentially a competence matter, and they would deal with it on that front. I don't know if you agree with that, Lucy.
Professionalism, certification,
conduct.
Yeah, I don't know. I don't know. And I kind of think, I don't know. I think most of us would be more worried about a Medical Council process than the HDC one, where at the beginning with an HDC process, the first step is nearly always that you give your point of view and what's in the notes and actually what happened, and it feels just quite wrong that actually that step didn't happen before it went to the Medical Council, because although you can say, oh, well, look, it's just a different process, it's HDC or Medical Council, does it matter? The doctor will be able to give his response to one or the other. I'm sure that's what the HDC's opinion would be. It's like, well, it does, it's just choosing jurisdictions, but they're going to get that opportunity at some point. But I think from the doctor's point of view, it might feel like it's an escalation. Don't you think? I don't know.
Oh, look, I agree with Sam. Getting that letter from the Medical Council, which the preliminary letter always includes the possible outcomes of this may be, everything from no action through to some quite serious consequences. And look, we're pretty much all sort of doomsday people when it comes to authorities. And you look at that and you think, oh, God, I'm going to have the worst possible outcome rather than the best.
I'm going to lose my practicing certificate and be struck off. That's where everyone goes.
So there's no way that I think any doctor can be comfortable about receiving a letter from the medical council. Certainly it's an outcome that if you can avoid it and have a quicker resolution, otherwise it would be it would certainly be worthwhile. It's also worth noting on that point that you raised, Lucy, about getting input from Dr. Smith. And in fact, New Zealand Parliament has stated that the two fundamental principles of natural justice are that affected parties should be given the opportunity to be heard, and that decision makers should be unbiased.
But I think the HDC would say here they weren't making a decision; they were just choosing a jurisdiction.
They were making a decision. It's a decision to refer it to the medical council, which in itself has a significant impact on the, state of mind of that doctor receiving that letter.
Yeah, I'm a little bit more on the fence about this. You could talk me either way, to be honest, because I think for me the concern would be which is the most appropriate forum for this to be heard in, and I think it would be best if it wasn't heard in both. And according to this letter, it states that it would be referring it to the medical council and waiting for the medical council to report back to the HDC on the outcome. And I guess it would come down to which agency would provide a better process for both the complainant and the doctor.
For me, it still comes down to the fact that the doctor concerned has had no chance to put their case, and therefore, before any kind of decision is made, should not the principles of natural justice apply?
We're looking at a very analogous situation to when ACC treatment injury claims are referred through to the medical council, where the doctor doesn't have any right of response before that goes to the medical council there either, do they?
But that's written in law. Yeah. So, and I actually don't think that ACC as an organisation is terribly comfortable with it, but they also don't see that the chances of having the law changed.
Sorry, just going back to your point, Tim, I think that had the HDC allowed the doctor to respond, it could have been resolved very quickly or not, but I guess there was a possibility of a really quick resolution.
Let's read on. So Dr. Smith requested assistance from us, and in fact he queried whether it was worthwhile responding to the HDC or whether it was just best to wait for the medical council process. I had a good look at the file, and I thought that a response back to the HDC was definitely worthwhile. So Lucy, can you tell us what happened next?
Okay, so with Tim's assistance, 2 days after receiving the HDC letter, Dr. Smith responded to the HDC and included phrases along the lines of, "I have not received any request from you to provide information regarding the facts of this case. I understand that in the interest of natural justice, you need to consider all the facts before making any decision. I believe my account will provide you with all the information you require to determine that there has been no concern about the appropriateness of my conduct, and I request that you reverse your provisional decision to refer this case to the medical council."
Actually, I was quite restrained with some of my suggestions because at that stage, I have to say I was feeling somewhat, involved with what had gone on. In fact, 4 days after sending the letter to the HDC, Dr. Smith received a reply from the HDC.
4 days is very quick for the HDC. That's
very quick,
very impressive.
Yeah, so, really to be congratulated that there was that quick a response, and I think that's great. After carefully considering all the information on file, I have made a decision to conclude my assessment of this complaint without referring this matter to the medical council. Thank you for your assistance.
That's an amazing outcome.
One amazing speed of outcome as well, yes.
When you think they were about to refer this to medical council. So I take it back, Tim. No, it shouldn't go to the medical council. It should have stayed with the HDC.
Yeah, and clearly there was more than just what the phrases that Lucy's read out. So what happened was that Dr. Smith was able to provide the HDC with an affidavit that he had written for the courts in May of last year. So this is well before the complaint process started. In that affidavit, he outlined all of the contacts he had had with his patient. He had followed up with her after the adult children had raised their concerns about her changed behaviour. He'd checked with hospital staff and asked them whether they had noticed that there'd been any significant change in her behaviour. When the mother approached Dr. Smith to say that she wanted to change her will and her EPOA, enduring power of attorney, Dr. Smith asked her detailed questions about this and received clear and consistent answers, indicating that she did in fact have capacity to make these decisions. And then a short time later, Dr. Smith was approached by the lawyer for a confirmation of capacity at the time of changing the will. There were also a number of other contacts between Dr. Smith and his patient over this period, and in his view, the mother remained lucid and consistent sort of during that time. So clearly a very different side of the story to what we got in the complaint. And Lucy, after reading just the complaint, we had concerns about whether Dr. Smith had followed a proper process. Thoughts now?
Yeah, it's sometimes very interesting to hear how different the viewpoints are of the complainant and the provider who's being complained about. And often the provider has the advantage of having notes, and having an affidavit is even, more unusual. But it is, I find that shocking how different those accounts are. But clearly, from Dr. Smith's account, he actually did a really good job of actually doing a proper capacity assessment.
Yeah.
And that the complainant, whatever the reason for their view, maybe either wasn't aware or the facts didn't suit them.
It's hard to imagine that complainant wasn't aware. It was an affidavit for a court case that he was pursuing through the courts, and he would have had access to all of that information.
So do you think this was vexatious, Tim, that the complainant was actually just trying a different avenue, having failed with the courts?
The complainant was clearly aggrieved by the loss of asset that occurred as a result of the change of the will, but actually made a number of statements that, they were just not true in this complaint.
We do see that, though, don't we, in complaints, where the complainants give a version of what happened, which is totally at odds with what the doctor says and what are documented in the clinical notes and can be corroborated by other staff members. It's quite interesting. And so I guess for all of us, when we read cases, particularly the ones that you read in the Herald, where they've got an account from the aggrieved person, that we all have to take that with a grain of salt, because there are always two sides, aren't there? There are always two sides.
And that's the challenge, isn't it? Because you get a complaint which read pretty lucidly. It sounded
articulate and reasonable.
And it sounded reasonable. Clearly, the complainant was very concerned about what had happened, and that came through in the wording of the complaint. But it wasn't one of those kind of ranty complaints that we sometimes see, which you think, oh, this is completely illogical. It seemed to be all there. And it does really concern me that we're vulnerable as providers to this kind of thing. And if any authority looks at it and starts making decisions without having seen the other side of the question, and I think the speed with which the HDC changed their minds here reflects that once the true facts were presented, then the logical decision was made. And that was great that happened, and happened so quickly. Yeah, there are always two sides to a story. So.
There are two sides. Yeah, and I think about,
critical.
certain media stories that you've heard, and it seems increasingly common where the media interview patients who've apparently had adverse outcomes or didn't have something treated, etc., etc. And when you know the backstory, when you know the other side of things, which we often do, often that side never comes out in the media, and it ends up being, everyone takes a side without realising that it's unbalanced and perhaps untrue.
And we often get queries, don't we, from our members about, can I correct what is out there in the media. And it's actually very difficult because, you may not have consent from the individual concerned to provide the true information. And we're often in that terrible position of saying to our members, look, I'm sorry, there probably isn't anything you can actually do to correct that misinformation that's out there. It's incredibly frustrating, isn't it, not to be able to put the other side of the story. And so it was very satisfying in this case to be able to do that.
You obviously did a great job here, Tim.
No, Dr. Smith did a great job, in fact, and all I had to do was just present the affidavit, and that was all that required to convince the HDC. But it did involve getting all of the information rather than only one side of it.
It's interesting. Do you think obviously we all know that the HDC is under huge resource constraints too. Obviously the medical system is under resource constraints, but so is the HDC.
Yes.
Do you think that might have had an impact here? Do you think that might be?
Well, it could certainly have had an impact on the fact that it took 4 months for the first letter to be sent out. And yes, look, maybe, I'm just imagining things here, but maybe the complaint did look so sort of logical and, made sense that it must have created an impression, yes, there is something here that I need to act on.
Yeah. And that this is a conduct issue, so therefore it's the medical council.
Yeah. So...
Yeah, we'll never know whether it was an issue of resource constraint for the HDC, what part that played in referral to the medical council, because certainly by pushing it to the medical council, the HDC didn't need to look into it. And we do know that they do have resource constraints. That's why complaints can take 2-3 years to be resolved, or even to hear from them after the initial responses go off. And I think that that's very unfortunate because it's not great for complainants and their families. It's really tough for them. But it's equally very tough for our members to have this hanging over you for such a long period of time.
And talking of complaints and the impact on them, with this particular case, I think, here we've got a complainant who's clearly vexed and sure, I think the complainant has done things which I can't condone. But after the initial letter from the HDC, the complainant must have formed a view, oh, great, this doctor's finally going to have something happen, the medical council is going to consider it. And then what happens, less than 2 weeks later, gets another letter saying, no, the situation's completely changed. So if I was the complainant, whatever my motivations might have been, I think I would have felt unhappy at that total reversal of a plan. Even if you argue that referral to the medical council is not a big thing, which,
it's hard to argue,
yeah.
Well, I have to say that it was a surprise, a pleasant surprise, to hear that the HDC could move that quickly.
Yeah, that was great. Really good, yeah.
Really good for the member.
So what about these false accusations then? Because we're seeing that a lot more, and we've had a number of cases with the medical council alleging, sexually inappropriate examinations or whatever, and certainly there is, we've discussed previously, Sam, the implications for the practitioners involved is huge.
Oh, it's massive.
But there's no balance, is there? There's nowhere that, there's no organisation that providers can complain to about complainants making false statements or anything like that.
No, sadly there's not. And it is hard because, obviously under Right 10 of the Code of Consumer Rights, every patient has a right to make a complaint.
Mm-hmm.
And so they have to be taken seriously, even if we know that they are vexatious, or we have a strong suspicion that they're vexatious. So it is very difficult. And I don't know what the answer to that is, Tim.
No, well, by the time this podcast is published and produced, the Medical Council will, the HDC will have received all of the submissions and considered them for review of the Act, which occurred in the middle of the year, and so it'll be interesting to see if any of those issues are addressed in that, and some of the other things that are impacting on the HDC as well.
No, it's interesting. And it is that I've often had doctors say, there's a patient code of rights. Is there a provider's code of rights? What rights do providers have? But I think the whole thing there is really that actually that whole power imbalance issue. At the end of the day, providers do have rights. They're not. The HDC is not there to uphold them. That's not what the HDC would see their role as. Even though they have, as you say, there is an obligation for natural justice and fairness. The HDC's role is there to uphold
protect the interests of consumers. Yeah,
Right.
absolutely. Yep. And they wouldn't be doing a good job if they didn't do that.
No, exactly.
Final thoughts on this case? Any other lessons?
I think your point about the process of natural justice is so important, that we as clinicians have a right to provide our side, to provide our response. And I guess that one of the things for our listeners perhaps is to say, you have the opportunity, and it's good to take that opportunity to provide a comprehensive and robust response. And often the best way to do that is to contact your indemnifier, isn't it? Because we can certainly help in the same way that you assisted with Dr. Smith. And I would think that there are times when we can certainly help quite a lot, because most doctors, hopefully, haven't had a lot of experience in responding to complaints. Yeah. And so it's hard to know exactly what is needed, what you should write, what you shouldn't write, all of those sorts of things. Whereas that sort of thing, we do this every day. And so it's really helpful, I think, if people do contact their indemnifier and just get a bit of advice.
I think the other thing that this case shows is that just the facts is often all you need.
Yes.
We often get quite defensive. All this stuff about you, that makes you feel like I'm not that kind of doctor. You can feel quite aggrieved by what's said, and that can create a response that is quite emotive sometimes. But actually, in most cases, what you need is the facts.
The facts speak
what
for
you need is the
themselves.
facts, and if the facts speak for themselves, you don't even have to address the accusations, because the facts will make it clear what's actually happened. And getting back to the oldie but the goodie from medical protection, that's why notes are good. Having really good notes makes such a big difference when actually it's the facts that matter, and that actually whatever that complainant's motivations were, however vexatious or unfair the actual accusations were, if we actually respond with emotion to that, actually we're probably going to get ourselves in worse situations than if we just say, here are the facts, look.
Except that it's impossible not to have those emotions.
Here's me saying, yeah, of course it is. But maybe that's partly what we're here for as well, is that when we read these responses that our members write, we often can say, well, what are the facts, and actually let them speak.
And I well remember having done this role as a medical legal consultant for a number of years and thinking, well, I'm going to get a complaint again at some stage, but, having done this job now, being a professional in it, I'll be totally, dispassionate about it, and I'll be able to just respond. Well, when the complaint did finally arrive, no, I was completely wrong. I was very emotional about it. It really had a big impact. And I was just incensed by some of the things that seemed so unfair in it. So, no matter how much we prepare ourselves,
that's right.
the emotions are there.
That's exactly the same for me, that I got very upset when I got the
I think for all of us. And I think, it's good to know that we're all in good company, that we all react the same. And that it's always hard, even when we receive a vexatious complaint, that it is tough for any of us, and to not underestimate the impact that it has. And, I think it reflects the fact that we all have high standards for ourselves, the care that we provide and the effort that we go to help our patients. And most patients are incredibly grateful, aren't they?
Yeah.
It's just the odd one or two who perhaps are less grateful. And it's those few people that can really ruin your day and your week and make you want to quit.
Absolutely. But I think that's also partly our role as medico-legal consultants when we get the information
Yes.
from our members, is to be able to get back to them and reassure them and say, look, actually, sure, it's upsetting getting this complaint, but, when I've assessed it, I don't think you've done anything significantly
Yes.
wrong. I think your vulnerability is really low, or whatever the assessment might be. And I think our members get value from that fairly
Absolutely.
instant reassurance that they're not going to be immediately struck off as a result of this complaint,
Yeah.
which is sometimes what we hear as their concerns. So it's an important role that we have.
And I find it gratifying when you can say to someone, actually, I think your vulnerability is low, so I don't think you need to worry about this. It doesn't matter if it goes to the medical council or the HDC. I don't think you need to be worried. And the sigh of relief at the other end is often palpable.
Mm-hmm.
But then sometimes, of course, we make mistakes as well. So that's the other
Sometimes
big
we
part.
are vulnerable.
In this case here, obviously, the member wasn't vulnerable because actually he had done the right thing. But honestly, but I actually sometimes feel it's funny when we've made a mistake, sometimes it actually feels all right to actually have to respond to that. Often it feels worse having to respond to something when you haven't done anything wrong and you think this is not fair. Whereas actually if something has gone wrong and there's been an adverse outcome, often it can feel like, no, actually I need to address this and the patient has a right to hear this. And so it can feel worse when you're not vulnerable, because actually that's the situation where
when
it's not. It just seems
a
so
baseless accusation. Yeah. No, that's true. I think in either way, it never feels good to get a complaint, whether you're vulnerable or not. I think we all take it the same way, don't we?
Yes. I'm touching some wood around here.
But yeah, no, I think probably the last word I would say is to our members, just get in touch with us. Just talk to one of us at the end of the phone and we can help you through the process. We can give you a different perspective, hopefully, a more objective look, and be able to walk through the process, however long or short that is, just step by step.
And well done, Tim.
Yes, well done, Tim.
As I say, it was really Dr. Smith who did it all, and all we had to do was just point it out. So that was great. So look, thank you very much, Sam and Lucy. I think I've really enjoyed this discussion. It's been very good. So thank you for your contributions. Thank you very much for listening to this podcast. I do hope it's been helpful. We look forward to catching up with you in our next podcast. And if you like these medical protection podcasts, please subscribe and leave a review. A good one, of course. If you would like a podcast on a specific topic, please email nzpodcasts@medicalprotection.org.